In the United States Supreme Court, the most important issues in American life reach their final judgment. In Washington, D.C., 9 justices serve as the final voice in the nation's legal system. These are their opinions.
On March 15, 2025, the United States removed Kilmar Armando Abrego Garcia from the United States to El Salvador, where he is currently detained in the Center for Terrorism Confinement. The United States acknowledges that Abrego Garcia was subject to a withholding order forbidding his removal to El Salvador, and that the removal to El Salvador was therefore illegal. The United States represents that the removal to El Salvador was the result of an administrative error. The United States alleges, however, that Abrego Garcia has been found to be a member of the gang MS-13, a designated foreign terrorist organization, and that his return to the United States would pose a threat to the public. Abrego Garcia responds that he is not a member of MS-13, and that he has lived safely in the United States with his family for a decade and has never been charged with a crime. On Friday, April 4, the United States District Court for the District of Maryland entered an order directing the government to facilitate and effectuate the return of Abrego Garcia to the United States by no later than 11:59 p.m. on Monday, April 7. On the morning of April 7, the United States filed this application to vacate the district court's order. The Chief Justice entered an administrative stay and subsequently referred the application to the court. The application is granted in part and denied in part, subject to the direction of this order. Due to the administrative stay issued by the Chief Justice, the deadline imposed by the district court has now passed. To that extent, the government's emergency application is effectively granted in part, and the deadline in the challenged order is no longer effective. The rest of the district court's order remains in effect but requires clarification on remand. The order properly requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. The intended scope of the term effectuate in the district court's order is, however, unclear and may exceed the district court's authority. The district court should clarify its directive with due regard for the deference owed to the executive branch in the conduct of foreign affairs. For its part, the government should be prepared to share what it can concerning the steps it has taken and the prospect of further steps. The order heretofore entered by the Chief Justice is vacated. Statement of Justice Sotomayor, with whom Justice Kagan and Justice Jackson joined, respecting the court's disposition of the application.
The United States government arrested Kilmar Armando Abrego Garcia in Maryland and flew him to a terrorism confinement center in El Salvador, where he's been detained for 26 days and counting. To this day, the government has cited no basis in law for Abrego Garcia's warrantless arrest, his removal to El Salvador, or his confinement in a Salvadoran prison. The government remains bound by an immigration judge's 2019 order expressly prohibiting Abrego Garcia's removal to El Salvador because he faced a clear probability of future persecution there and demonstrated that El Salvador's authorities were and would be unable or unwilling to protect him. The government has not challenged the validity of that order. Instead of hastening to correct its egregious error, the government dismissed it as an oversight. The government now requests an order from this court permitting it to leave Abrego Garcia, a husband and father without a criminal record, in a Salvadoran prison for no reason recognized by the law. The only argument the government offers in support of its request, that United States courts cannot grant relief once a deportee crosses the border, is plainly wrong. The government's argument, moreover, implies that it could deport and incarcerate any person, including U.S. citizens, without legal consequence so long as it does so before a court can intervene. That view refutes itself, because every factor governing requests for equitable relief manifestly weighs against the government. I would have declined to intervene in this litigation and denied the application in full. Nevertheless, I agree with the court's order that the proper remedy is to provide Abrego Garcia with all the process to which he would have been entitled had he not been unlawfully removed to El Salvador. That means the government must comply with its obligation to provide Abrego Garcia with due process of law, including notice and an opportunity to be heard in any future proceedings. Federal law governing detention and removal of immigrants continues, of course, to be binding as well. Moreover, it has been the government's own well-established policy to facilitate an alien's return to the United States if the alien's presence is necessary for continued administrative removal proceedings in cases where a non-citizen has been removed pending immigration proceedings. In the proceedings on remand, the district court should continue to ensure that the government lives up to its obligations to follow the law.